Welcome to another edition of the Legal River Podcast, a weekly look at the laws and legal issues facing small to medium-sized businesses.
Hi, my name is Steve Obensky and I'm an attorney in Washington, D.C. Copyright law is important to just about every business, but it is frequently misunderstood. So in this video, I just want to discuss what is a copyright and how is it created, some simple steps that you can take to help protect your business copyrights, and probably most importantly, how to help ensure that your business actually owns the copyrights in materials that are created for you by your employees and your independent contractors. So let's start with what a copyright protects. A copyright protects the author of a work against unauthorized copying, and also gives the author the sole right to create derivative works that are based upon that original. To create a copyright in the US, there are actually only two simple requirements. The first is that it be an original work of authorship, and the second is that it be fixed in a tangible medium of expression. The first requirement, originality, simply means that it took some creative effort to produce it. So, for example, the content on your company's website, your logos, if your company produces software or reports, all of those things can be the subject of copyright. Copyright law, by the way, does not protect brand names or slogans. In some cases, those can be protected by trademark law. That second requirement was that copyright be fixed in a tangible medium of expression. And all this really means is that it be written down, recorded, posted on your website, or something like that. So that's all that's required, but there are some additional things you should do to help protect your copyrights. The simplest ones are providing a copyright notice and registering your copyright. These are actually, as I mentioned, not required, but doing them removes any doubt that you intended to protect your legal rights in that work. And if you do go to court later, having done these can actually greatly increase the amount of money damages that you can receive from someone who has infringed your copyright. The copyright notice is very simple and it's seen everywhere. You simply put the word copyright or the copyright symbol, which is a C with a circle around it. You also put the name of the author, which in the case of most businesses is going to be the company name. Make sure that you do correctly spell it and punctuate it. And in addition, you want to have the year of first publication. The copyright registration takes only a little bit more effort, but it's a relatively simple matter of filing some forms online. You can find those forms on copyright.gov. Now, how do you make sure that your business actually owns the copyrights in materials that are created for you by your employees and independent contractors? For these types of transactions, a written contract is important for several reasons. Under federal law, ownership of a copyright can only be transferred with a written contract. If you don't have a written contract, you and the contractor are probably going to be considered joint owners of any work that you both contribute to. And this can be a problem for a couple of reasons. One of them is that the joint owner is generally going to be free to copy and use the work for whatever purposes they wish. And the second is that the joint owner actually has the right to approve or disapprove any future sale of that work. So especially if you're in a business that where you may be selling some of the materials or where you plan to sell the entire business in the future, you'll want to have a written agreement that says that any important copyrights that you use in your business are actually owned by you, and only by you. Also, even if you intend that your contractor is going to keep some rights in the work, you'll probably want to have a written agreement that makes it clear what they're allowed to do and what you're licensed to do. Just to give you an example, if your company hires a web designer to create, say, the logo for your company in addition to creating your website, you'll probably want to own the copyright in the logo so that your designer can't go off and use the same logo for somebody else. But you may not mind so much if your web designer then goes and uses just the templates from the pages, maybe a background color or something like that. You may not care about that so much if they go off and use it for someone else. So even if you're in that situation, you'll want to have a written agreement to make it clear what exactly you intended when you entered into that agreement. Now, you may read that copyright law has a special provision called works made for hire. And what this means is that if work is made specially commissioned for your company, then it becomes the property of that company. But even that provision requires that there be a written agreement specifying that it's intended to be a work made for hire, and for that reason, you still can't get out of having the written agreement requirement. In some states, just to complicate matters further, especially in California, the way you construct this agreement can actually have important tax and employment law consequences, so you will want to consult an attorney just to make sure you're using a form that is proper for your needs. Finally, there is a bit of good news. Works made by an employee are, within the scope of that employee's employment are generally considered owned by the company without a need to do anything further. But as you can imagine, in many industries, it can be unclear what exactly is the scope of employment. And this can obviously especially be the case if you have employees who are working side jobs or do other things outside of the office. So in that case, you may want to include a copyright assignment as part of your employment contract or as part of the employee handbook, or in either way have something in writing that makes it clear what the company intends to be the property of the company versus something that the employee could take with them somewhere else. So this concludes a brief overview of copyright law for businesses. If you have any questions, please feel free to give me a call at steve@obensky.com. Just a reminder that this is intended to be general information and should not be construed as legal advice. And finally, if you have any questions about the podcast, feel free to email podcast@legalriver.com. Thank you.
Thanks for listening to this edition of the Legal River Podcast. If you have a business law question you would like to see answered in a podcast, please email us at podcast@legalriver.com. To reiterate, all views expressed in this presentation are intended only as a general discussion of the issues and should not be regarded as legal advice. For additional details or advice about a specific situation, please consult legal counsel directly.